SJC-11683 and SJC-11937, Commonwealth v. Ronald C. Dame.
Mr. Reardon, good morning.
Good morning, Your Honors. If it pleases the Court, my name is Attorney Theodore Reardon. I'm here on behalf of the defendant, Ronald Dame. Your Honors, the first issue presented today is that the defendant's motion to dismiss should have been allowed. The victim in this case died in 1974. The defendant was charged 32 years later, in 2006. During that time period, 19 years after the murder, the defendant's alibi witness died, and therefore the defendant was prejudiced by the delay that occurred in this case. And in fact, there was no reason not to prosecute this case. In the words of the Commonwealth, it had a great circumstantial case back then.
Yeah, but it didn't have the DNA.
Yes, and in regard to the DNA that was performed in 1999-2000, that DNA, at that point the DNA had degraded, and it proved that 1 in 49,000 people had that particular DNA. And in the city of Fitchburg, where this occurred, there were about 43,000 people at the time in 1970. And therefore, this evidence, the DNA evidence that was involved in bringing the indictment, was not anything particularly significant in bringing it. And in fact—
Sir, I'm sorry, I don't get that. It was a 1 in 49,000
Yes.
random possibility.
Yes.
And
in
that's,
Fitchburg—
and that in light of the other evidence, would not turn out to be a rather compelling piece of evidence to add to the weight of what they had before?
Well, I think it's relative to the other evidence that they had, it's relatively insignificant, and standing by itself, it is not particularly significant when you consider that in the city of Fitchburg, there were 43,000 people living there at the time. But more importantly, that DNA evidence was not the triggering event for bringing this indictment. Well, the DNA evidence came back in 2000, and the defendant was not indicted until 6 years later, 2006. So this DNA—
But your prejudice is essentially triggered by the 1993 death of the alibi witness.
Yes.
So what's the significance of the additional 6 years since she was dead already for 7 years at the time of the DNA first being discovered?
Oh, I cite that for the proposition that the DNA evidence was not the triggering event that caused the DNA.
Didn't they do more DNA work with more sophisticated kinds of tests between 2000 and, I forget, 2004 or 5 or 6 or something?
After the indictment. After the indictment. Oh. The DNA evidence that came out at trial was performed after the indictment. So the DNA testing that was performed in 1999, the results came back in 2000, that was not a triggering event that caused the DA to go and say, ha-ha, now we've got this DNA evidence, we can go and seek an indictment. Because they didn't do that. They waited another 6 years to indict. And so I cite that for the proposition that this did not significantly affect the Commonwealth's case. And again, the Commonwealth, its position was when the defendant tried to pursue a third-party culprit defense, the Commonwealth's position was that it recited to the judge all the evidence that it had in 1974. And it characterized the evidence as a great circumstantial case. And in the 19 years that the defendant's alibi witness was alive, there was no ongoing active investigation. There was one blip 9 years after the murder where the Keene, New Hampshire police contacted the Fitchburg police with a possible lead. And the Fitchburg police went up to Keene, New Hampshire and followed up on that lead. And all that really showed was that someone else they had previously looked at was not involved.
Counsel, let's get beyond the 30, whatever it was, year delay and talk about what it is that you have to show to make that important to us.
Yes.
Number one, you've got to show that it was intentional or reckless. Where is the evidence of that in this record?
Well, part of my brief is also arguing is that the court should be considering a negligence standard.
Okay, so you're not suggesting that it was intentional or reckless?
Oh, yes. No, I am suggesting it was reckless. So we're not making—
But then tell me what the evidence of that is.
The evidence was that they had they had a great circumstantial case in 1974. There was no significant development that came about for 32 years when they sought the indictment, and that the defendant was prejudiced by that delay, and that the failure to indict when they had not just enough evidence to indict, but to convict in 1974 was reckless in doing so. And in light of the fact that...
That doesn't help me. You're just telling me what the test says.
Yes.
What do you know that would be supportive of that proposition? What do you know about what they did or didn't do?
Well, this is what we know, that they did nothing between 1974 and
I get that.
Yes.
So you've got to show that the reason they did nothing was intentional for some purpose, I don't know, or it was reckless.
Well, we're not making an intentional argument. We are saying it was reckless and or negligent. And in light of the fact that they had enough evidence to convict the defendant in 1974, and they didn't pursue that, and in light of the fact that the defendant's alibi witness died, it was reckless for them not to pursue that.
So how does a court
And
get
negligent.
involved in that decision? We don't know everything that the prosecutor had in front of him or her. We don't know what the problems were in the case. So how can a court say in these circumstances that it was reckless not to proceed with the case?
Well, reckless or negligent.
Okay, reckless or negligent.
Yes. Well,
We'll come back to negligence.
yes. Well, there was a hearing on this, and the Commonwealth's argument during that hearing was basically that this was all normal, and that this delay was nothing out of the ordinary, and that it was perfectly acceptable. That was their position. They did not contest the defendant's timeline about the lack of investigation between 1994 and when the indictment was brought. They didn't cite too many kind of extenuating circumstances or anything else that was going on. So the Commonwealth had an opportunity, if there was some kind of circumstance, to elucidate the court, but it did not do so.
That was your burden, though, wasn't it?
In the motion to dismiss?
Right.
Well, we did. The defendant put forth all the discovery that was provided to the defendant and provided a timeline that said nothing happened here for 32 years. The only thing that happened was the Keene, New Hampshire contacting Fitchburg. There was no active investigation by Fitchburg. And all that did was confirm that someone was not involved in this. And so the defendant met the burden of, or I'm not sure if the defendant produced a timeline that showed that nothing was happening, that he was prejudiced by the failure to indict when they could have indicted and convicted. And the Commonwealth did not propose that there was anything that excused it. In fact, they said this was normal. They didn't even acknowledge that there was something wrong with this. So that's the position.
But wouldn't you be in a stronger position if they had indicted in 1998 as opposed to after the DNA evidence came in?
I don't think so, because the DNA evidence, as I say, I don't think that is anything significant to the Commonwealth's case.
And did your argument depend upon that?
Yes, well, I think you can, because, in fact, as I say, the Commonwealth did not indict for another 6 years until after the DNA evidence came in. So the Commonwealth can't cite to the DNA evidence as providing that extra evidence that caused them to seek the indictment. It was basically...
Why can't it?
Well, because if it was that additional evidence that was the turning point for the case, then they would have sought an indictment after the DNA evidence came back, and they didn't. They waited 6 years.
On the prejudice part,
Yes.
the Commonwealth says, well, yes, she was an alibi witness, but there's all these other witnesses who saw him at the bar, and, that there was a lot of evidence to suggest that he was not at his sister's house playing with his niece until 3 minutes before midnight that night.
Right.
So we have to weigh that also?
Right, so I addressed that in the reply brief, and the focus of the response to that is twofold. First of all, the Commonwealth only had 3 witnesses in question. The 2 additional witnesses, they say there's no statement from them. But the 3 witnesses that they have placed the defendant at the bar up until 9:15 at night. But the Commonwealth's theory at trial was that the murder happened between 10:30 and midnight. So these witnesses don't place the defendant at the bar.
Yeah, but it's whether the hours completely match up, it is inconsistent with the idea that he went to his sister's house and he stayed there nonstop, that's his position, right? And that's what his sister testified to. He came and he didn't leave again, and he came much earlier than 9:15.
Right, but in response to that, I cited the case, I think it was I forget the name offhand, but in my reply brief, there was a similar situation where this court dealt with a partial alibi witness. And in this case, the Commonwealth has a partial alibi rebutting witness because it doesn't cover the time period of the death. And in that case, there was error by the Commonwealth in the cross-examination of the alibi witness. But the court said that was not reversible error because the witness was only a partial alibi witness, and even if everything that was taken at face value of that even if that witness was taken at face value, the crime still could have been committed, and therefore that error was not reversible. I'm applying that analogously to this case, in that in this case, the Commonwealth's witness is only a partial alibi rebutting witness. And even if everything is taken at face value of what these witnesses say, LaPlume, the defendant's alibi witness, was still a complete defense because their witnesses don't contradict her testimony.
Now, you argued Drayton in your reply.
Yes.
What would be the standard of review for that?
Well, what I argued was similar to the drug cases and the Verdi cases where counsel didn't object at trial because it would have been futile to do so. And likewise, in this case, trial counsel told the jury in the opening statement that there was an alibi witness, but they weren't going to hear from her, which I cite that for the proposition that counsel knew that her statement was not admissible under the then evidence rules. And therefore, his failure to offer them into evidence would have been futile. His attempt to offer them would have been futile.
The other cases, where it was Melendez-Diaz, where there was controlling authority that said it's not admissible, the admissibility of hearsay from a deceased witness that claims to be an alibi, was it so clear that that was not a proper objection?
I'm unaware of any authority that could have come in before your decision last month. And certainly there was no discussion about it by the DA or the judge or anything else like that about a possible evidentiary exception to that coming in.
And is the evidence here as strong as it was in Drayton with regard to its admissibility?
I think so, more so actually. As I pointed out in the reply brief, in Drayton, there was an affidavit that was created presumably by defense counsel that the Commonwealth had no knowledge of the circumstances of its preparation. And the court also cited to the frequency, repetition of the statement as bearing on its reliability. In this case, we have 3 statements by the alibi witness to 3 different sets of detectives. And the Commonwealth, unlike in Drayton where the Commonwealth didn't know the circumstances of the statements, here they actually observed it. And when the witness was challenged on the veracity of her statement, she threw the officers out of her house, which goes to show her insistence on the accuracy of her belief that this is what happened.
But in Drayton, there was no relationship of any consequence between the witness and the defendant, and here it was the girlfriend.
I'm sorry, I don't follow you.
Or the sister, I'm sorry. In Drayton, the person, my memory is the person who testified was in the bathroom, and although she knew the defendant, there was no particular reason to think that she would lie to help him. But here, it's his sister, and one would think that she would lie to help him.
Right. Well, the Commonwealth tried to make that point in its brief too. That she's the sister, and so how weighty can her testimony be considered? And I responded to that in the reply brief by pointing to cases where the defendant, 4 cases, where the defendant had testified as to his alibi, and his corroborative witnesses, whom he says could corroborate his testimony, did not testify. And in those 4 cases, the Commonwealth asked for a missing witness instruction, and they got it. And the issue on appeal was the defendants were saying, no, 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 the witnesses were cumulative of my testimony, I didn't have to bring them in. And the court said no. The court said that the missing witnesses were central and of distinct importance to the case. And in one of those cases, it was the defendant's brother, it was a cousin, it was a girlfriend, and it was a next-door neighbor. So in each one of those cases, and in particular I'll focus on the brother, the court held that the failure to have the brother testify in corroboration of the defendant's alibi testimony entitled the Commonwealth to have a missing witness instruction. And so I'm saying to you, likewise, in this case, the defendant's sister is a central and distinct a witness of such distinct importance that her testimony cannot be dismissed as merely cumulative or, it's his sister, so how much can we weigh on that?
But in Drayton, didn't we send it back?
Yeah, we didn't, well, we sent it back for hearing. We
Send
didn't
it back
allow
for
it
hearing. We
in.
didn't say it was going to be admitted.
Yes, so I was just responding to Judge Gant's question about how much.
No, I understand that, but I mean, so what relief are you looking for here? It wouldn't be that, that somehow that this means that there was, in fact, prejudice.
Well, the first thing we're looking for is for the case to be dismissed.
I understand that, but you can
Yes.
only do that if you
Yes.
if you show prejudice.
The second, okay. And you're also looking for, if there's a new trial order, to admit this testimony?
Yes, that's what I'm looking for, yes, 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 yes. I hope that answers your question.
Not exactly.
Okay.
I mean,
well,
in what respect are you raising Drayton?
I'm raising Drayton in that, in the event that we're unsuccessful on.
In the event that you're unsuccessful, you're not raising this in connection with the motion to dismiss. This is only in connection with the motion for new trial?
Oh, yes,
Oh, okay.
yes, I'm
I
sorry.
missed that.
I'm sorry. Yes, in the event that the court did not dismiss the case, it should be reversed for a new trial, or should be reversed at a minimum for consideration of whether these statements should come in at a new trial. Yes, yes. Are there any further questions on the motion to dismiss?
Well, just one quick question, but I take it when you say, that sticking to reckless or intentional is a mistake, you should include negligence.
Yes.
But as I understand the test, as you describe it, it's really a matter of degree, because in other words, it depends, it somewhat changes the weight in balancing prejudice versus conduct on the Commonwealth's part, right?
Well,
But
yes, well, that is what we're arguing, is that the court should be developing a balancing test of looking at the reason for the delay and
I guess even under the reckless, you're still balancing.
Yes, yes, yes. And I cited, the Commonwealth claims that the Supreme Court has definitively ruled that there is no negligence consideration on this, and I think it's clearly wrong. I cited to you a plethora of cases where other jurisdictions have held otherwise. I cited to you the Hu case where the U.S. Supreme Court justice the court denied certiorari, but in dissent, one of the justices pointed out that this is an active issue that has not been decided by the court, and a 2013 law review article that talks about how this is an issue ripe for consideration by the
We
court.
would have to overrule Imbruglia to get to your negligence
Yes, you would.
argument, right?
Yes.
So, in the cases that I'm aware of where negligence has been applied as the standard, have shown a high degree of prejudice, which seems to be missing in this case.
Well, it's the defendant.
So in other words, if we were to adopt a standard that would take into account negligent delay, applying that balancing test, this particular case wouldn't justify it where the prejudice is not so clearly established. And I think the cases use something like substantial and actual prejudice or something like that.
Well, I would suggest there is substantial prejudice here, and as I say, in the other cases where a witness did not testify in corroboration of the defendant's alibi, the defendant didn't put those witnesses on, the court has held that the Commonwealth is entitled to a missing witness instruction because such testimony is central to the defendant's case, and it's of distinct importance. And so applying those adjectives and that reasoning, I would suggest to you that there is substantial actual prejudice that the defendant could not put forth his alibi witness's testimony. And because of that, he was substantially prejudiced.
Okay, thank you.
Thank you, Your Honor.
Good morning. May it please the court. Donna Marie Heron, Assistant District Attorney on behalf of the Commonwealth. The motion judge in this case properly denied the defendant's motion to dismiss, where the defendant failed to demonstrate either that the pre-indictment delay substantially and actually prejudiced his defense, or that the government intentionally or recklessly caused the delay.
How did this work then? How did this all of a sudden come back to the surface?
In the DNA evidence, and that was the argument made below. I actually made the argument below.
Somebody submitted the DNA evidence.
In 1999, the case as a cold case was reopened, and at trial, we learned from the DNA expert that in 2000 and 2002 was when DNA technology started to becoming available. Due to the limited quantity of it, there was testimony in 1999, the Mass State Crime Lab sent it out to the FBI lab, came back, and I disagree with my brother. I believe it was clear that when the first DNA results came in, it was sent for more specialized testing, and indeed in early 2006, as in the trial testimony, they took another swab from Mr. Dame to do a more comparative, the YSTR testing, and based upon those, that the indictments were then sought. I believe the DNA was what drove this case and what was helped convict the defendant.
So they took the additional swab before the 2006
Before the indictments came down in early 2006, it was testified at trial, and another second swab from Mr. Dame, along with George Dutton, who came up in the 1983, which the police investigated, and Jerry Duheim, the boyfriend of the victim.
So in terms of the motion to dismiss, and I don't know the record of this, did you submit an affidavit, or was it just argument, or how did it was Judge Lemire who decided that?
Judge Lemire, we had, no evidence was taken at this. It was argument, and we each,
The affidavits?
I think it was a grand jury testimony in the police reports that we submitted as to what occurred during the course of this case up to 2006, after the indictments were issued. And the Commonwealth strongly argued it was the DNA that was the catalyst, and I would suggest to you it's the reason why the defendant was convicted, based on the scratch marks and the right hand fingernail scrapings. And the Commonwealth also strenuously argued that the defendant failed, and that Judge Lemire specifically found that the death of the sister did not constitute substantial actual prejudice to justify the drastic measure of a dismissal. And I would contradict my brother here. There was 5 witnesses, and it's on Record Appendix 49, that were at the bar that testified that between 7:30 and 9:30, between roughly those times, the defendant was at the bar, and they were quite sure the defendant was at the bar. In addition, we had the defendant's girlfriend who stated to the police and also testified at trial that the defendant came to her house around 6 o'clock that night. They got into an argument because she was going out with another man, and the last thing he said to her was, "I'll be at the bar if you want to come see me." And then we have the victim's own husband who told police that he left his house around 7:38, and that the defendant was not at his house at that time. So I think Judge Lemire was more than warranted in determining, when looking at this evidence in light of all the other evidence, that it was not a substantial actual prejudice to his defense.
But even if that was wrong, you could still prevail because of the first prong of this.
Yes, I believe it's clear that it was the DNA that drove the reason why this case was indicted.
But wasn't there strong evidence that whatever happened around 11:45 or midnight, not at 7:30 or 9:30?
Yes, but it shows the credibility of the sister's testimony when and I would also say at the third time when the police interview her, this is after now they've interviewed all 5 witnesses at the bar, they come back to her and they said, are you saying that your brother's with you? What are the exact times? And she says 6:30 to about midnight. They said, we have 5 witnesses at a bar that unequivocally place your brother at the bar till at least 9:30. What do you have to say? She starts crying, gets up, goes into the pantry, and then tells him to get out of her house. I believe you could look at that in a different light and saying that she was disturbed by this because she knew she was caught in a lie, and that's why she kicked him out of the house. And I believe that was argued below as well.
Kind of tough, though, for the judge to be balancing the credibility this way, isn't it?
I think the judge is appropriately weighing this testimony in light of all the other testimony that would have come in at the time and making the appropriate determination as to whether this constitutes substantial actual prejudice.
But he wasn't the trial judge. I mean,
No,
there
he
was,
was
I'm
not the
sorry.
trial judge.
This was before the trial.
This was before the trial, but he had all the police reports which outlined both the husband's testimony, the girlfriend's testimony, and the 5 witnesses at the bar. And I believe he appropriately weighed that in and determined that the defendant failed to meet his burden and appropriately denied the motion to dismiss.
You say 5 witnesses at the bar. Did 3 of them testify at the trial?
Only one testified at a trial in rebuttal, because the defendant did testify at trial that he was at his sister's house and that his niece scratched him, and Robert Powers in rebuttal testified that he was at the bar. But in the police reports on page 49 to 50 in defendant's record appendix, there is the Powers, Mr. and Mrs. Powers, gave statements to the police. Norman LeBlanc, who was a patron of the bar, Richard Caron, another patron of the bar, and then the bartender, all gave statements to the police saying the defendant was at that bar. And I said, in addition to the girlfriend, where the defendant last says to her, "I'll be at the bar if you want to come get me after you."
So this really played out in the defendant's testimony in the rebuttal
Yes, at trial.
at trial.
And in regards to the Drayton case, I would like to.
Before you go there, the sister told the police he was here until midnight, and what happened at midnight?
She said he went. She said he leaves. The defendant testifies, "I just went to bed. I went to my house
She
and went to
said
bed."
he left around midnight?
Yes, she said the defendant left the house just before midnight and said he was going home. The defendant testifies at trial, "I went home," and told the police that back in 1974 as well. That's what he told police he was.
And is there any evidence as to how far away the sister lived from the victim?
Not the sister from the victim. There was testimony how far the defendant lived from the victim, which I think was about a mile.
Right.
But I don't know if there's any testimony elicited as how far. I believe there's testimony that she lived in Fitchburg. I don't know exactly. I don't think there ever was an exact distance as to how far her house was from the victim's house. In regard to the Drayton case, I think this case clearly is an opposite of that case. In Drayton, you found that the fact that there was only one eyewitness who was the essential evidence of the case, and that the fact that his girlfriend at the time submitted an affidavit where she's saying she's dying of cancer, and that this one eyewitness, which is the sole evidence, is lying, that witness was actually with her at the time of the, was, I think, in the bathroom, doing drugs and other thing at the time.
They're completely contradictory stories, right? I mean, the defendant,
Yes, and that was the sole evidence of the case, and you stressed in these unique circumstances, you were sending it back for a hearing to determine whether there's enough trustworthiness of her statement to show that it should have been admitted into trial and to have a hearing. Here, we have the DNA evidence, which I argue below, which was my view, what sunk the defendant in this case. The scratch marks on his face and when the DNA evidence matched him under her fingernail scrapings, which takes it out of the realm of an eyewitness who gets contradicted. As noted before, the trustworthiness of her statement is clearly undermined by 5 people at a bar, the defendant's own girlfriend, and the sister's own husband who contradict her statement. So I believe on this record it falls way out of Drayton and would not be admissible under that.
Now, help me, I gather in the motion to suppress, there was information about the victim's child witnessing somebody coming in, but I guess a trial, that was not offered?
No, he was 3 years old at the time the son witnessed the murder. He talked to the police. This is not admitted at trial. He did not testify at trial for the Commonwealth. I don't think he was confident enough to remember everything at the time. But he did give a statement to the police saying that a man broke in, and he did give contradicting statements to the police.
Black man who cut off her ear? I mean, he had a bunch of stuff.
Yes, he had, which is why the Commonwealth did not offer his statements in, because it was too contradicting. But I think it was clear, though, that he was in the room when the victim was murdered.
And Mr. Dom is white?
Mr. Dame is right, yes.
Okay,
There are
thank
no
you.
further questions. The Commonwealth rests on its brief.